And that is something, that is where the actual trade started, and that is where the people started understanding the importance of intellectual property. So intellectual properties are not very recent. We have combined them into laws and made them for the societal benefits. But intellectual properties are ancient. Okay, and people knew their importance since ages, like thousands of ages. Okay, now when you look at this particular picture of Coca-Cola bottles, it showing you the type of bottles. It went from 1899 till 1991, and now the shape is almost the same, which has been made until 2025. There is no change in the shape. So this particular shape of bottle, color of bottle, remains as an intellectual property of Coca-Cola. If you see this particular color of Coca-Cola, it is not a red color. It is a specific type of red color which Coca-Cola has created, and that particular color is also a intellectual property right. Okay, when you look at the iPhones, which went from 2007 to 2024, you can actually see that size of iPhone has changed, the types of camera have changed, the design has changed, the internal architecture of the circuits has changed, the type of touch is changed, everything is changed. Everything comes under IP. So when we talk about intellectual properties, and as and when you start understanding different parts and meanings of IP, you actually start mixing up all those properties together. I mean, I say that this particular thing should have been a patent, but it has some part of copyright, it has some part of trademark, it has some part of circuit design, it has some part of geographical indication as well. Okay, so understand that there is a very, what you can say, a very faint line between different types of IPs when it comes to protection, and that is why knowing and understanding the legal jargons is very, very, very important. Okay, so we'll talk about patents in details in further slides, but first understand how this particular intellectual properties grew globally. Okay, so there are different types of intellectual property starting from patents, confidential information, layout, circuit designs, geographical indications, copyrights, and industrial designs, and so on. Okay, so we'll talk about development of WIPO, development of GATT, development of WTO, TRIPS agreement, and other important provisions. First, I will quickly go over it, and then we'll have a small 1-2 minute session if you have any questions. Okay, so first let's talk about development of WIPO. So what happened is in 1873, when revolution was happening in European countries and they were going out and trying to trade with different countries in the world, like British came to India. They had an exhibition in Austria, Vienna, in 1873. But most of the foreign exhibitors in the sense, all the exhibitors outside Austria, all these exhibitors, they refused to join it because they were frightened that our invention might get stolen. हमारा काम चोरी हो जाएगा. So that was the main problem, or that was the main threat these people felt. And this actually motivated for the first round of intellectual property rights management, which happened in 1883. As it happened in Paris, it is called as Paris Convention. Now understand that whatever such kind of meetings happen, international meetings happen, those are called as conventions. Okay, so it happened in Paris, so it is called as a Paris Convention. Okay, so this particular Paris Convention happened for protection of industrial properties, where specifically we'll talk about patents over here. And there are many signatories to this particular Paris Convention. So when I talk about signatories, that means people who actually signed this Paris Convention. Even India was a part of it. Okay. So this particular Paris Convention will come later when we talk about patents. In 1886, people realized the importance of copyrights, literary work, and artistic work like paintings, poetries, or prose, whatever you write, whatever you create. And that actually Bern Convention, it happened in Bern. So that was specifically for copyright. And then was Madrid Agreement or Madrid Convention, which happened in Spain specifically for trademarks. So as you can see that from 1873 exhibition, 1883, immediately in 10 years there was Paris Convention, immediately in 3 years there was Bern Convention, immediately in next 5 years there was Madrid Agreement, and in 1893 there was Burpee that was established. So it is an international bureau for protection of intellectual properties, and it happened in Bern. Okay, so that was established. Now important thing is we are considering only from the perspective of protecting the intellectual properties. But from 1893 till 1970, when Burpee became WIPO, WIPO is World Intellectual Property Organization, there was no significant movement in between in terms of intellectual properties, because that was the season when the countries got into the causes of World War One. Then there was World War One in 1910, 1920s. Then there was World War Two in 1930 to 1940s. Then there was a Cold War. So world was entirely going under continuous revolution in terms of territories, in terms of properties, in terms of the political revolution, industrial revolution, everything. And that was actually giving turmoil to this particular intellectual property arena. Okay. So the Burpee became WIPO in World Intellectual Property Organization in 1970. So almost after 80 years or 75 years, this particular change happened. And then WIPO joined United Nations, and then entire system came into picture. Okay, so the main reason to tell you all this particular type of what you can say, the evolution of intellectual properties, because you should know that intellectual properties are not restricted to a specific country. So whenever my country or whenever India is going into intellectual property, it is solely from the perspective of trading with other nations, getting their currency in our country, moving our currency in their country, and getting our GDP higher, the gross domestic progress. Okay, so GATT was developed in 1945 and actually 1947. So, General Agreement on Trade and Tariffs. What does this mean? Let's don't get into my slides at this particular moment because they are more very confusing. So, what happens is India is, uh, let's consider there is one country, let's say US. Now, US wants to trade something with UK and trade something with India and trade something with Germany. Now, for the US, if they do not like any of the product from one of the countries, what they could do is they will increase the tariff barriers for India. Like, for example, they will say that if you are selling out a good of $5, you have to give $1 to my country. Okay, that means 20% you should give as a tax to my country. Now, when the same rule is applied to UK, consideration becomes a little different. And they say, instead of if you sell something of $5 in my country, you give me only 10% taxes. Now, this particular tariff and trade barriers can go from country to country. What I mean is, it can change from country to country, and any country can do that, right? So, this is called as favoritism. that this country is my favorite country, so I will make my rules a little softer for this country. This country is something what is trying to get into my business, so I will make my rules a little harder so that that country cannot invade into my business. Okay, so this can be done at the international levels, and that is why this particular general agreement on trade and tariffs was coined, under which people said that it is a multilateral agreement and people who are going to sign it, they are going to have same rules for all the countries under consideration. Okay, so that was this particular agreement. That is why it is called as general agreement and not specific specialized agreement on trade and tariffs. Okay, this particular GATT, which was developed after World War II in 1947, when India got its independence, over a period of time in 1995, through this GATT, WTO was established, that is World Trade Organization, and this particular Paris Convention was the motivation actually for development of TRIPS agreement by WTO. So TRIPS is Trade Related Intellectual Property Systems Agreement. So TRIPS agreement. Okay. So anyone has any questions till now? So for now, you just have to remember that something happened in Paris, and that particular Paris, Bern, and Madrid Convention, they made significant changes in world trade, from which GATT was developed, that is General Agreement on Trade and Tariffs, from which WIPO was developed, World Intellectual Property Organization, and they two combined together in 1994. TRIPS was prepared, that is TRIPS agreement was prepared. WTO, World Trade Organization, was.
Sorry, is it these WTO TRIPS agreements and GATT and all is applicable to only to US or to any countries? It is applicable.
No. So this is a world agreement. So that is why it is a World Trade Organization. And TRIPS agreement is for the entire world. I'll talk about certain provisions under TRIPS agreement, which are very interesting, rather important.
And it varies between country to
Anyone
country.
Sorry?
It varies between country to country. When any goods come to India, that time tariff may be different, or when goods sent to the US, again that may be different, right?
No. So under TRIPS agreement, according to the currency value, we can change our rules. So these agreements are made so that every country will get enough time and directions to make their own laws. Okay, what I mean is TRIPS agreement has certain, so it has articles. So it says that this is the patent and these are the rules that you should apply during patent law. Now the consideration is these are the directions given under TRIPS agreement when you sign it. Now US will develop its own law based on the TRIPS agreement. India will develop its own law based on the TRIPS agreement. Germany will develop its own law based on the TRIPS agreement, but all three countries have signed TRIPS agreement, so the baseline foundation remains the same. So TRIPS is just an agreement which gives the direction for development of the judiciary system of every country. Okay, I mean, in India, if I have to make Indian judiciary system, matlab High Court, Supreme Court, District Court, and if they want to make their laws, they will make their laws according to the TRIPS agreement. In US, if I want to make the federal court, high court, or Supreme Court, they will make their laws according to the TRIPS agreement. Okay, there will be slight differences in their law structures, but the basic foundation or basic rules remains the same. Okay, for example, touchscreen for mobile which is purchased in India is same, touchscreen purchased in the US remains same, but there are certain features which are specific for US or specific for India. Okay, let me give you another example, that if you purchase a Honda City in India, City Honda, whatever, India, or Honda Accord in India, there are too many speed breakers in the way. And that is why you have a good ground clearance in Indian Honda City or Honda Accord. If you buy Honda Accord in the US, the ground clearance is almost half of it because there are hardly any speed breakers present on US roads. So car is same, the company which is making these are same. Only thing is the design is different according to the country. In the same way, the TRIPS agreement is a worldwide agreement which was signed by different countries, but the provisions under this particular agreement are adopted by different countries, and their laws were adapted to the TRIPS agreement. Got it right?
Yes, yes, sir. Thank you.
Yeah, thank you, Dhananjay, for asking that particular question because this part is really important later on. Okay, let's move on, and you will understand that particular thing. So the first and very important article under TRIPS agreement. So again, whenever there is an international agreement, there are articles. Whenever there is a national law book, or we can say Bare Act, there are sections. So in whenever I will talk about Indian Patents Act, I will have section 3, section 4, section 46, section 84. Whenever I talk about international TRIPS agreement, I will have article 3, article 4, article 5. Okay, so that is the main difference between the two. So what is the article 3 talks about the national treatment. The national treatment is, suppose an Indian company devises a patent, and that Indian company wants that particular patent to be patented in the US, and they file that particular patent in the US. At that particular point of time, that particular Indian patent should be given all the privileges of the US patent. Okay, so the Indian patent and Indian patentee, that means the person who is filing the patent, the Indian patentee, will be treated as US national when this particular patent application will be processed. Okay, so all the laws and regulations which are applicable for US patentee remains the same for in Indian patentee. That is called as national treatment. I am not going to change my laws for the international people. That is what we call as national treatment. Okay. Article 4 talks about most favored nation treatment. When I talk about most favored nation treatment, the name is a little bit confusing, but the meaning is you should treat every nation as the most favorite nation or a most favored nation. Okay, that means there is no discrimination between the countries. That is what the law says. That is why it is a very important article of most favored nation treatment. Article 6 is very interesting, exhaustion doctrine and parallel import. I'll talk about that. Article 31 about compulsory licensing and Doha Declaration. I will talk about that. And also mailbox period. I'll talk about it if I am not wrong. Yeah. So let me talk about exhaustion doctrine and parallel import a little later because this is something what all of you can relate to. Okay. So let me move down to IPR in India. So you should first know that where are these intellectual property offices. Okay, so how it is controlled. So under government of India, there is Ministry of Commerce and Industry, like Department of Commerce. A part of it is Department for Promotion of Industry and Internal Trade. Okay, which is DPIIT. Okay, and a part of it is your Office of Controller General of Patents, Designs and Trademarks. Okay, so overall it comes under Ministry of Commerce. Okay, so this is how there is hierarchy in Indian political system. Okay, and departments. Now under this particular department, there is Indian Patent Office, which is also an Indian Designs Office. These offices are there in Kolkata, Delhi, Mumbai, and Chennai, but the head office there in Kolkata. The Trademark Registry Office is there in Kolkata, Delhi, Mumbai, Chennai, and Ahmedabad, and the head office there in Mumbai. There is Geographical Indications Registry, and the office is in Chennai. Copyright Registry and the Semiconductor and Integrated Circuit Design Registry is in Delhi, and Patent Information System and IPR Management System is in Nagpur. Okay, so you should know where you should go for filing these things. So this is very important. Like people know everything about it, पर कहाँ जाना है वही पता नहीं होता. So that is why this is very very important for everyone to understand that. Okay, so these offices are especially under different big cities, metropolitan cities. Okay, no problem. Now, important thing you all should understand that intellectual property rights are not regulated by any separate judiciary system in India. Okay, what I mean is the court which works on the criminal proceedings, the court which works on civil proceedings, the same court works on IPR proceedings. Okay, so the judiciary system remains the same, that the local district court, high court, and supreme court. Okay, so the system is the same. There is no change. Absolutely. Got it? Now, just because intellectual property rights are a specialized types of rights, there is a separate board to which you can make a complaint or you can file a complaint to, is called as IPAB, which is Intellectual Property Appellate Board. Okay, and Intellectual Property Appellate Board works in harmony with High Court. So I will talk about it in the further slides. Okay, so first understand this is how the judiciary system works for the intellectual properties. Okay, so this is the judiciary system. This is not a legislative structure. Legislative structure remains same. Legislative matlab legal structure remains the same. Local district court, high court and supreme court. Nothing changed. Okay. So any questions till this point? Anyone has any questions? Yes, no. I mean, if you do not ask questions, that means either you have understood everything or you have not understood anything.
Yes, clear the point, sir.
Yes, thank you. So let's move on and let's talk about this general principle of patent. Now I am moving to the Indian Patents Act. Okay. So until now we were talking about international developments in terms of intellectual properties. Now we'll talk about the Indian Patents Act hardcore. Okay, so this is a section 83 in Indian Patents Act, which talks about general principle of patenting. So the first thing that they mention, that patents are granted to encourage inventions and to secure that the inventions are worked in India on a commercial scale. Okay, so they talk about why are they granted. Okay, now the second about why they are, what do they not mean. So they are not granted merely to enable patentees to enjoy monopolies in the market. That means मुझे पेटेंट मिला है इसके लिए I will stop others from using or stop others from doing that. No. Okay, so you cannot have monopoly. There has to be a competition. If there is competition, then only there is upgradation. Okay, so it is not granted to merely enjoy the monopoly in the market. Okay. Apart from that, there is promotion of technological innovation. It should not impede with the protection of public health and nutrition. Now, this is a very important part considering goal of MSc. Okay, so it should not impede with the public health. And important thing that you all should consider during this entire patent act is whenever you read about the act, there is a word called as third party, third party, third party. So what is this third party? If I am putting up a patent or I'm putting up a copyright, or I'm putting up a trademark to the copyright office or patent office or trademark office, I become the owner of that particular invention, or I become the owner of that copyright. Okay. Who is giving me that particular right is the government. So government becomes the second person. Okay. So first person who asks for the right. Second person, that is the government which gives the right. And the third person can either ask me or the government to license or assign that particular right to the, or they can steal that particular right. So that person becomes a third person who is not involved with this one to one interaction. Okay, so understand this particular who is the third person in that. Okay, so general principle of patent, just understand that it is not to enjoy monopoly, it is to encourage inventions and do not impede health and nutritional benefits from the society. Okay, now there are important criteria for inventions. Okay, so this is a very interesting quote by Steve Jobs. So he says that, to me, ideas are worth nothing unless executed. Okay, so this particular statement is very, very important. Why? Because something comes in my mind, I think about that particular thing. That is an idea. That becomes an intellectual property. But that cannot become a property unless it is materialized. Okay, so that is very important. Execution of idea can be patented. You cannot patent the idea. So remember that. If I think that I make a sphygmomanometer which can detect the patient health from a distance. Okay, so I have designed that particular instrument. I'm specifically talking about sphygmomanometer because you guys are well versed with these instruments. So I have designed it, and I can do the patient monitoring from the distance. Now I have designed it on paper. There is no actual implementation of that. I will say कि ये मैंने invent किया है and I need that particular right, and I go to the patent office. Patent office is not going to give you the patent for that. Why? Because it is not materialized. Why? Because it has not shown its industrial applicability. Okay, so unless and until you execute the idea, unless and until you materialize the idea, that idea cannot be patented. Okay, so that is very important. So execution of idea becomes the primary step. Okay, so there are four important criteria for patentability. The first is novelty. So when I talk about the word novelty, the important definition, it should not be anticipated by prior public knowledge. Okay, or there is no mosaicing of prior art. What do you mean by prior public knowledge? I give you a nice example for that. So this is a real time example. That one time a company was making a bicycle which is children friendly bicycle. Okay. Now the company took different volunteers from different areas of India, or of the country. I'm not naming the country. Okay, so they took different volunteers from different areas. Now the thing was, this particular invention was yet to get into the market, and the testing was very much important before putting it into the market, and that is why the company had written all the non-disclosure agreements, and all the parents of the children volunteers had signed it. Now children below the age of 18 are not legally allowed to sign any of the agreement. Their parents are supposed to, on their behalf and on children's behalf, right? Now the thing happened that these parents used to get their children for testing the bicycle, and give their reviews, what is good, what is bad, and so on and so forth. One day, a lady, I mean, a mother of a child, she couldn't go to this particular demonstration park, and she asked her maid, like the house help, to can you go with my child because today I cannot go. So the maid went there. Now maid knew that, oh wow, this is how the bike works. And when she came home, she told many people that this is how the things work. Now, when this particular company went into the market, went to the patent office and filed this particular patent, this particular patent knowledge was already in the public. Why? Because his maid had already told many people about it, and even different industries knew about this particular thing. Okay. Now the maid was not abide by the contract to not tell to anyone. Right? Understand this particular scenario where the parents had signed the legal agreement, not the maid. So legally, maid did not do anything illegal. Company did not have enough vigilance on who is coming with children, and that is why this particular mistake happened. And they actually lost around $200 million contract. Okay, so this is how this is a very famous case, and let's not discuss which was the company and so on and so forth. So, did you understand the importance of novelty? So, this is how the prior public knowledge comes into picture. So, this is called as prior art. So, whenever I talk about prior art, this is what prior public knowledge. People should not know. Okay. Now, the second part comes is inventive step, and then they talk about non-obvious. Just give it a try. Anyone. Just give it a try. Anyone. आहेत ना सगळे? Who is the person skilled in the art?
The person who experienced that.
Who is talking? Oh, then. Yeah, I'm asking you. Tell me a person who has experienced it. Is it like the company owner? Is it like the engineer, or who becomes a person skilled in the art?
Labor,
What what do you mean by labor?
the person who is working in the workshop.
Who is?
The persons who are working particularly on that particular things, like workers.
Like people who are working on tractor designing.
Maybe.
Okay. Any other answer? Any other answers?
That might be a driver.
Driver of the tractor.
Yes.
Who drives the tractor?
Owner of the tractor.
Who owns the tractor? I mean, what jobs do they do?
Farming.
Yes. So farmer. So all these people, starting from the owner who has designed the tractor, who has made different parts of the tractor, the architect, the farmer who is going to use the tractor, that farmer's wife, if she is going along with him in the farm, everyone becomes person skilled in the art. Each and every person. So there is no specific definition of person skilled in the art. Okay. Now, in my earlier example, that maid also become person skilled in that because she has seen that particular bicycle working. Okay. And that is a very fragile area in patent protection. Okay, that is inventive step. Then there is a third important criteria for patentability is industrial applicability. Now, this is a very important criteria in India. So, unless and until you can commercialize your patent, unless and until you can get money out of that particular patent, you cannot get the patent. Okay. On the contrary, US has utility patent. Utility patent matlab Your patent will be usable. It can be usable by the industry or it may not be usable by the industry. It may make money or it may not make money. That is irrelevant. It should be usable. It should be applicable. May not be to the industry. So that is industrial applicability for India, and it differs from utility patents in the US. Okay, so industrial applicability matlab your patent should get money in some time. Okay, and the fourth and very important criteria, which most of the books do not talk about, it your patent should not be present in Section 3 and Section 4 of Indian Patents Act 1970. Okay. Now, what is Section 3 and Section 4? So, Section 3 talks about what are not inventions. Okay, मतलब मैंने पंखा बनाया, and if I put a light to it, that particular, so initially fan was giving me proper hawa and all, and the bulb is plugged to it. Now I have combined two different things. This is called as mosaicing of different arts. So that is not allowed under Patents Act. So things which are just यहाँ पे किधर से- just a mere admixture of two things. So light is giving light, fan is just rotating. They are having their own functions. वो एक साथ आने के बाद they are not giving any different look or different ideology to that particular invention. It is useless. If you consider कि fan घूम रहा है, and then that it is generating some sort of physical energy, and through that physical energy is light is lit, that way you are saving on much of the energy, then you can call it an invention. Then it is not only an admixture. Here you are giving energy only to only to the fan. Fan is generating energy through the wind, and that particular wind is pulling in the energy and giving it for the light lit night. Okay, so this can be an invention, but just admixture of two things is not an invention. Very important, inventions which are contrary to the established natural laws are not considered under patent. Inventions which are against morality or which are injurious to the public health, not invention. Inventions relating to the atomic energy are not patentable. Okay, they become the property of the government. Okay, मतलब कल किसी ने जाके if you have seen the movie Wednesday, I don't know if people have seen Nasiruddin Shah ka movie, where he says that I have made bombs using washing powder. Now that becomes an invention, but that is not patentable. Why? Because it is against, it is injurious to public health, and again it becomes an atomic energy, although it is going to do the same thing as an atomic bomb. Yeah, so it is not patentable. Now I talk about Section 3D of Indian Patents Act, which is very important, which talks about mere discovery of any new property or new use of the known substance is non-patentable in India. Why this particular section is very, very important? Because there was a famous Gilliweg case which happened. Now let's boil. Do you have any questions till this particular point? Anyone has any questions about criteria for patentability and what are not inventions and atomic energy?
Yes, cleared the point.
Okay. Any no one else has any questions?
Sir, regarding this patent and all, so far whatever the patent has been registered or permitted, is it list is available in the patent registry department? Is it visible to everyone?
You can even go online. You can even go online on IP India, and you get all the patents.
Yes, sir.
And even more than that, I would say that I will talk about that. So, patent search is another important area. As you, the question was really relevant. So, for patent search itself, you have to buy the softwares, which are very, very costly, like $1,000 subscription per month or something like that. Okay. So, patents are available, all the patents are available. But if I want to search for a specific patent, So there are different criteria by which you actually search for them. We'll talk about it in later slide if time permits. Any other questions till now? Because I'm going to go back to TRIPS agreement and then come to Glivec case. No questions.
Please
Sangre
continue,
Hushar
sir.
best. Sorry?
Please continue, sir. Sorry.
Yeah. So now we'll talk about the famous Glivec case. So what happened is in 1995, all the countries in the world they signed TRIPS agreement, Trade Related Intellectual Property Systems Agreement. Under this agreement, there were directions for developing your laws. Now, when I talked about the law, I said Indian Patent Act 1970. So the Modern Patent Act is an amendment of this particular original act. Indian Patent Act original was made in 1920s when British were there in India. Now this is the Modern Patent Act which was actually made in 1970, and over a period of time as the world was changing, people were making amendments in that. When I talk about amendments, that means changes in that particular act. Now why these changes are important? Because there are new inventions, new discoveries are made, and different things happen. Now important thing is when in 1970 there was no invention of DNA 4 or something, and he received his Nobel Prize in 1987. Harry Mullis, yeah. Now this was a development in the field of molecular biology, which was a very important development. So I had to change my laws accordingly because this particular invention was worldwide. Okay. So as technology progressed,